Hello friends, in the series on the income tax cases, today we will discuss a very important issue. The issue is like this, that if during the assessment proceedings, the assessee as well as the subscriber of the share capital submits all the documents before the learned assessing officer, then whether in case of non-compliance of section 131 notice, and that too only restricted to non-appearance before the learned assessing officer, can become the sole ground for making the addition under section 68 by denying or by questioning the credit worthiness of the share subscriber. This matter has been discussed in the case of Rainbow VINCOM Private Limited versus Income Tax Officer, which has been reported in 108 ITAT Tribunal Short Notes 19. The matter has been decided by Kolkata ITAT B bench and the date of the judgment is 10th November 2023. In the present case, the assessment year is 12-13. It means the financial year is ending on 31st March 2012. And in the opening balance of the financial year, there was a share capital share premium balance of rupees 2.06 crore which the assessing officer made addition under section 68. First of all, because this was the opening balance, so this cannot be added into the income of the assessee of the assessment year 12-13 because this was not received in the financial year 31st March 2012. This was the one issue. The second issue was that when the assessing officer made inquiry regarding the identity, creditworthiness and genuineness of this share capital, the assessee submitted all the relevant documents, that is bank statement, share application form, income tax return and all other documents which were necessary for complying and for proving the creditworthiness and genuineness of the transaction. Apart from this, the assessing officer issued notice under section 131 to the share subscriber, to which the share subscriber replied and submitted all the documents again. But the share subscriber did not appear personally before the assessing officer. The assessing officer took this against the assessee and made the addition in the income of the assessee to the tune of rupees 2.06 crore. The assessing officer did not point out any defect, did not point out any deficiency in the documents which have been filed by the assessee and by the share subscriber. When the assessee moved to the CIT appeal confirmed the order of the assessing officer and he also didn't make any inquiry. CIT appeal also did not point out any defect and deficiency in the document submitted by the assessee and he upheld the order of the assessing officer as it is. When the matter came before the ITAT was of the opinion that in the present case, neither the assessing officer nor the CIT appeal did not point out any deficiency or defect in the document submitted by the assessee for proving the creditworthiness of the transaction. Then in that case, simply because the share subscriber has not appeared before the assessing officer cannot be taken as a ground to draw a negative inference against the assessee. ITAT also said that the share subscriber is not under the control of the assessee, so that cannot be taken against the assessee that the share subscriber has not appeared personally before the assessing officer. ITAT said that in the case of Principal CIT versus Paradise Inland Shipping Private Limited, which was the decision given by the Bombay High Court, the Bombay High Court in that case said that when the assessee submits all the documents before the assessing officer about the identity, creditworthiness and genuineness of the transaction, then the burden shifts on the assessing officer to prove that there is any deficiency or not in that documents. ITAT further said that in the case of CIT versus Manish Bildwell Private Limited, that was the decision of the Delhi High Court in 2011, and in that case Delhi High Court has said that the CIT appeal has the co-terminus power with the assessing officer, just not limited to the appellate powers but also the power of assessment. And in the present case the CIT appeal has himself made the inquiry and should not have taken an adverse view against the assessee just because the shared subscriber has not personally appeared. So in the present case the ITAT deleted the addition made by the learned assessing officer, which was confirmed subsequently by the CIT appeal. At the end of this video, once again I am repeating the name of the case. The name of the case is Rainbow VINCOM Private Limited versus Income Tax Officer, and this case has been reported in 108 ITAT Tribunal, short notes 19. The matter has been decided by Kolkata ITAT B bench and the date of the judgment is 10th November 2023. Thank you, friends.